Ms. Ratliff, this is an appeal from General Sessions Court, which means it is what we call a trial de novo. And that simply means that even though you've been through this in General Sessions Court, you're going to have to reestablish and prove the reasons for, or the basis for the issuance of an order of protection. So you just need to start from the beginning as you did in General Sessions Court and let me know that. But I'm going to have you come and testify. We're going to need the witness stand. All right, Ms. Ratliff, if you will, please tell me what the nature of your relationship was with Mr. Hodge and why you feel that you need an order of protection.
Okay, good morning, Your Honor. So my name is Linda Ratliff. Mr. Hodge and I were previously dating, and we were not married, we were just dating in a relationship, which ended in October of 2024. So I filed for the order of protection originally in October of 2025 after enduring about 12 months of harassment and stalking, and I do have the police reports that I filed along the way that align with this, so I can kind of walk you through the timeline of just everything within those 12 months and what led us here today. So as I mentioned, the relationship ended at the end of October 2024, where I blocked Mr. Hodge's number and all of his social media accounts and any accounts that I was aware of at the time. The first contact attempt came from him in an email on October 31st, 2024, and that was initially what started all of this. Throughout November, there were other instances, one of which where my TVs in my house were linked to his Alexa account still, and he changed the screensavers on my TVs to old pictures of him and I. He also created profiles and changed names of accounts on my streaming accounts that he still had the passwords to. January 3rd, of 2025 was when I received the first text message from a number I did not recognize, and confirmed it was Mr. Hodge, and at this point I told him to stop contacting me. Other messages followed this, so what was happening was as soon as I would block one number, he would create an account on a texting app and it would generate a new number that I did not have blocked at the time. And so I have various documentation here of text messages that I received, all from numbers that I did not have blocked because they were new numbers. After this, I began receiving calls that were no caller ID calls that were coming through. There was flower deliveries made to my house. I have documentation of these photos. I also have the original cards, and also have communication with the florist confirming that they were from Mr. Hodge. On January 28th, 2025, I received an email from Mr. Hodge that contained a screen recording of all of his attempts to text my phone number, which was blocked. I assume he was trying to see if he was still blocked, but within the screen recording of all of these attempts, it appears to be in the hundreds of message attempts from him. I also received a voicemail. Even if you have a number that is blocked, you can apparently still receive voicemails from them on January 30th, 2025. After this, he began making social media accounts to try to contact me that way. I have documentation of this in February 10th of 2025. And at this point, I did file harassment charges. However, since he lives in the state of Kentucky, I live in Tennessee, those were very lengthy to process. They are now finalized, but it took a while throughout this for him to be notified of those.
Let me interrupt you and ask this question. You say that the harassment charges are finalized?
Yes, there is a court date, I believe, March 19th.
So there's pending harassment charges? In other words, you have a case where he has been charged with harassing you?
Yes.
And that case is still pending in court, correct?
No, there is no further court date set for that.
So what is, when you say it's finalized, that means different things to different people.
Okay.
What happened in that harassment case?
So as a part of his release conditions, I believe is what it was called, he agreed to an order to not contact me.
Okay. So there's an order in that pending criminal case that directs him not to have contact with you?
Yes, correct.
Okay, go ahead, I'm sorry.
No, you're fine. So on February 14th, so approximately 1 week after I had initially put the paperwork in for the harassment, he did come to my house. I do have camera footage of this. He left flowers in a 5-page letter at my house. I did not speak to him at this time. I was home, though, and as I said, I have it documented through my cameras. After this, in February, I again have multiple instances where there were calls, social media accounts. He also attempted to contact me through reaching out through my family members. It did, however, kind of become minimal compared to what it previously had been until October of 2025, at which point it escalated again. And at that point, I had received a text message with another screen recording of all of his text attempts to contact me. I have a voicemail from him documented on 10/23, more flower deliveries on 10/28, and again, communication from the florist there confirming that they were from him. I have a text message on 10/29 where he refers to trying to contact me, and he says, other than stopping by unannounced, I don't know what else to do, implying that he was considering stopping by my house unannounced. And then on October 30th of 2025, he made a social media post. It was an old picture of him and I, and the caption was, "I wish you knew how far I would go just to get a reply." So with this happening in October 2025, and again, having no contact with him since when I told him to stop contacting me on January 3rd, this was when I filed for the order of protection. I was really afraid that things would escalate. He would come to my house. And to be honest, I was just I'm looking for some peace and quiet here after all of these attempts to contact me. There was also some instances of erratic behavior throughout the relationship, where he at one point showed up to my house with a firearm and spoke of having suicidal thoughts. So this combined with these messages, I was just afraid of how things... I'm sorry?
When did that occur that he showed up to your house?
Several months before the relationship ended. It was probably early of 2024, I would say. But that is what led me to file for an order of protection. I will mention that like I said, I've had no contact with him. He does have a son. I did see his son twice, actually, during this time. So I initially just saw him at the mall. He was with his nanny of sorts at the mall that I was at, and he asked me to watch a movie with him. They were going to the movie theater. I declined at the time, and then later on, the nanny reached out to me and said that Issa had asked to see me and asked if I would meet them for lunch. I had thought at the time that she had cleared this with Mr. Hodge. Again, I had no contact with him. I later found out that she had not. But I did just want to mention that I did have contact with his son during all of this happening, but I had not spoken to Mr. Hodge.
How old is the son?
13.
All right. Anything else?
No, Your Honor, I believe that concludes my statement.
And this has been ongoing, and you said you have proof that you wish to, or the substantiation of some of these items, is that correct?
Yes, Your Honor, I have everything printed out here if you would like to look through them.
All right, if you will hand that to the bailiff and let the bailiff demonstrate that to Mr. Hodge so that he can look at it before it's presented to me.
Would you like the police reports as well?
Police reports are not admissible as hearsay, but if there's documentation of what you say was his behavior, then we'll take a look at that and see what's admissible.
A woman told the court her ex allegedly spent an entire year trying to contact her after their breakup, using fake numbers, social media accounts, flowers, voicemails, and even changing her TV screens to old photos of them together through his Alexa account. Then, the courtroom got silent when she revealed he once showed up with a firearm and later posted, "I wish you knew how far I would go just to get a reply." Now the judge must decide, heartbreaking obsession or dangerous stalking? What do you think? Comment below and subscribe for more courtroom drama.
These are in order, I believe. however she would like them? Can I take them out of order or flag them a certain way?
No, just leave them as is. I'm just showing them to you so that you know what she is seeking to introduce.
Okay, thank you.
Ms. Ratliff, you have submitted some documentation. There is a card here from the Petals on the Bluff. Is that one of the cards that was on the flowers that was delivered?
Yes, Your
And
Honor.
it says you deserve them. Do you know of anyone else who would have sent those flowers to you?
No, Your Honor.
In this documentation that you have submitted, there are a number of photos of no caller ID, missed calls, repetitive calls, and those are the calls you're referring to from his number, or from him, as far as you know?
The no caller IDs, yes, from him, as far as I know. There are a few instances in there documented where there were calls or voicemails from his work number and also his number via other apps like WhatsApp.
Here is a text message that you have dated February the 4th of 2025 that says, "I'm not asking you to talk to me. I'm not asking for you to reply. Just please unblock me. I have these thoughts running through my head all day, every day, and I need to let them out. You're the only person that understands me. I won't beg, but I also won't blow you up. There's a lot I need you to hear. You don't have to reply." And that's from a 270-262-3536. Is that his number?
That is not his number. That would be one of the numbers he, I believe, acquired through an additional texting app.
And then there's another, again, interspersed with these missed calls from an unknown no caller ID. There's a transcription from Jake on January the 30th of 2025 that says, "I get it. I know I need to talk to you. I need your help, please." Is that from Mr. Hodge?
That would have been from his phone number, yes. If you have a blocked phone number, you can still receive a voicemail. They just go into a separate folder, which is where that was located.
And then here's one in January 25 that says, "Block me here if you want, but make a TikTok about me. I'm okay with that. I've deserved that. But I have so much I want to say to you. I don't want anything out of it. I don't want to be friends with you. I'm damn sure not helpful of ever figuring it out. However, I just keep running across the same shit, and I can't deal with it anymore." Is that, then there's a number of unsent messages that were apparent. Were those blocked messages that show up on this?
So I believe that is within an email from Mr. Hodge, and he sent me that. So those are his attempts to send a text message to my number, and then he unsent the message before sending me the
And then there's one blue
screenshot.
screen that says, "Please help me." Was that one that got through?
That was, no, I never received that. That was just one he didn't unsend on his end.
Here's another one that's January 24th. It says, "I'm not okay. I know you want me to hurt. I understand, but I need your help, please." Then here are some that from January that basically says a series of conversations where you ask, "Who is this?" And then you say, he says, "Lastly, if you ever feel like unblocking me and talking, I think we both need that." You said, "I don't need that. Stop contacting me." He says, if this person says, "If that's really what you want, I get it. I don't blame you. Take care of yourself. I'm proud of you always." And then again, a series of messages. It says, "It won't go away." And you say, "Sorry, who is this?" And then it says, "Every fucking day I think it's going to feel better, but I can't go 10 minutes without sick effing feeling in my stomach." You ask again, "Who is this?" He says, "I hope you're okay. I see you're traveling. I know that at least makes you happy. That's all I want." So what, and then he goes on to say, "Lastly, if you ever feel like I'm blocking me and talking, I think we both need that." Did you have a period where you were traveling when he sent that message?
Yes, I do travel a lot.
And so that was an indication that he knew you were traveling. And this is a picture of the screensaver that he had changed without your knowledge or consent.
Yes, Your Honor.
Show a picture of you and him together.
Yes. That is on my bedroom TV in my house.
All right. And had this continued up until the point where you obtained the order of protection in this case?
Yes, Your Honor, it
Since that
did.
order of protection was issued by the General Sessions Court, has that stopped the contact?
Yes, it has.
And you're asking for that to be extended for up to a year, is that correct?
I would prefer that at this point. I would love for it to not be appealed and just be held for at least the year it was originally in place for.
This is the appeal. So today, if I issue an order, I can issue it for a period up to 1 year. And
Okay.
then within that 1 year period, if you feel that there's a need, you can come back into court and seek to have that extended for an additional 1 year period. And you can continue to do that as long as you feel that there is a substantiated need.
Okay, then in this case for the 1 year, Your Honor.
All right, I'm going to have these documents marked as an exhibit to this hearing.
Okay.
Mark them as a collective exhibit. Now, anything else you want to tell me about the situation?
I do not believe so, Your Honor.
What effect has this had on you as far as your state of mind during the time that all of this has gone on?
Mentally, it's been very draining. I use the same phone number for everything, my personal life and work, so to have all of this come through, it has really hindered my life as a whole. And honestly, just kind of constantly looking over my shoulder if he's going to show up at my house again, if I'm going to receive flower deliveries. It's really just been exhausting overall.
All right. Anything else?
No.
Mr. Hodge, you are acting as your own attorney. You have the right to ask questions of this witness if you wish to do so. You're not required to do so. Do you wish to ask any questions? If you do, you'll need to come to the podium.
Ms. Ratliff, have I ever endangered your life, hurt you, caused you harm physically at all whatsoever?
Physically, I've not endured any harm.
How long were we dating in total from start to end?
In total, approximately 15 months on and off.
Was this behavior a pattern?
I would say yes.
This would happen and then the relationship would continue, correct?
There are instances where the relationship was ended for a brief period of time, and this behavior did appear, I would say briefly, when the relationship had ended for a few days, yes.
Was there a time in March of 2024 where there was approximately 10 days worth of text messages from myself to you that were no reply and we continued a relationship after that?
I would say no, there were replies. We had spoke on the phone several times during that, I believe.
No further, Your Honor.
Thank you. All right, Ms. Ratliff, you may step down. Do you have any other witnesses that you wish to call?
I do not.
All right, then you may have a seat.
A breakup turned into a courtroom nightmare. The woman says her ex kept calling, sending flowers, making fake numbers, and even changing her TV screensavers after she blocked him. Then, the judge read a chilling message. "I wish you knew how far I'd go just to get a reply." The ex asked, "Did I ever physically hurt you?" Now the judge must decide if the protection order stays. What do you think? Love or stalking? Like, comment, and subscribe.
Mr. Hodge, the plaintiff has rested her case regarding this order of protection. You have the right to present proof if you wish to do so. It's my understanding, however, that there is a pending stalking charge that's still an active case in another court. And I would just remind you that you have an absolute right to refuse to answer any questions that are to not testify if it would tend to inculpate you or make you guilty of the charge that's pending. You have a right against self-incrimination, in other words. So I will hear whatever you have to say if you wish to testify, and then she can cross-examine you if she wishes. You'll come right up here.
First off, Your Honor, this was appealed because I had yet to be heard. not because of a judgment. If you want me to bore you with the reason it wasn't heard, I would be glad to do so, but I
want to hear from you of what you have to say regarding her petition for an order of protection and why you feel like it should not be issued if, in fact, that's the way you feel.
Thank you. What she described was a harassment case. There was not any endangerment threats, promises ever from my end. That's the last thing I would ever want. There are multiple instances where we had ended our relationship, and my persistence of trying to speak with her had begun another instant of our relationship, and there I have proof with me if you would like to see that as well. As far as her bedroom TV, I changed photos on all of my Alexa devices. It went to her TV as well, and that's not something I had unpaired at that time. It wasn't trying to backdoor any kind of secret, sly reasoning of changing her photo on her TV. That wasn't it. As far as her social media or her Hulu accounts, that I still had a login to that because we both used it. I mean, it wasn't, I just took my shows off of her profile and put them on my own. That wasn't a vulgar act of any kind. In October of 2025, just before this case saw the court the first time, we were at the same racetrack. We both drag race competitively. She knew I was there. She didn't feel threatened enough to leave or scared or have any protection there. I would never, ever do any of that. Let me see here. My biggest issue with the order of protection is that I'm a business owner. And my firearms, obviously, in this were taking away my right to defend myself. And my son and I travel the country, and we travel to Indiana and shoot competitively, target shooting with my father. We're not able to do that as well. I'm completely okay with the no contact order that was in place, and it was a harassment charge that we had the agreement for 1 year of no contact that taken place in March, I believe, of this year. The no contact order is completely okay. I don't have any intent to contact her. I don't have any intent to cause her any harm. I don't have any sort of ill will towards her whatsoever. I was, I think more or less I had a lot of guilt and regret. My actions led to this, and that's what led to me trying to contact her and talk through that. But as for the evidence she provided, I understand the assumption that every spam risk and no caller ID was myself. I get that. It was not. There was a social media post that before I was blocked on social media that she had posted a screenshot of a no caller ID missed call, knowing that I looked at it and it wasn't me. I knew that the call wasn't me, so I know every one of those is not me. Every spam risk is assumed as me. I understand the assumption. I'm not trying to run from that, but there's a text in there about braised pork ribs. I couldn't make that if I was asking if she was interested in braised pork ribs I was making for dinner. I couldn't make braised pork ribs if I watched a YouTube video while doing it. So not all those were me. Some of those absolutely. I'm not dodging that whatsoever. But as far as I would never show up at her house, that's why I said other than showing up, I don't know what else to do. And that was it. And I believe her and myself can both agree that there would be, if there was one conversation had, none of this would even be this far. But last and not least, the time she told me that whenever she was done with me, the only get back she would have is public embarrassment. And I believe that's what I'm going through. So that'll be it.
All right, Ms. Radliff, you have the right to cross-examine him if you choose to do so. You may ask questions. If you're going to ask questions, you need to come to the podium.
Thank you, Your Honor. Okay, so first thing, you mentioned that you would never cause me any harm and that I should be aware of that, but when you make a social media post that states that I have no idea the links you would go to just to get a response from me, I would say that's open to interpretation. Would you agree?
Absolutely. Would you like me to interpret that?
I think that you just answered her question. It's not what I want or don't want. It is the question that she asked that you must answer.
Yeah, that meant like on my end, I would change locations, change my life, my phone number, who I'm around. That wasn't, I would go to some physical extreme lengths to speak to you.
And then you also referred to a reference of when we were at the same racetrack last year. However, I had no prior knowledge that you would be there as we had no contact. And then can you also corroborate that I was with my
Ms.
father?
Ratliff, let me interrupt you. This is a portion where you may ask questions, but your questions are not to be statements made by you, but rather they must be in question form. If you have a question in question form, you may ask that.
Okay, thank you, Your Honor. One final question then. I believe you stated in your testimony just a moment ago that you would never show up to my house. Was that correct, or did I mishear that?
No, I stated that a conversation could have been prevented, all of this, and I wouldn't show up to your house unannounced. The day that you said I came, I did come, and you knew I was on my way.
I'm sorry, which day?
The one you provided on camera.
And I knew you were on your way.
Yes,
Do you have any written proof of that?
I do not.
Okay. Thank you, Your Honor.
All right, Mr. Hodge, you may step down. Do you have any other witnesses?
No, Your Honor.
All right, thank you. Mr. Hodge makes the argument, or makes the point, that there was no physical damage, no physical injury or threatening and so forth. So that you can make the argument that Ms. Ratliff is not a domestic abuse victim. But under 363602, which is the section of the Tennessee Code that provides for orders of protection, it states the following in subsection A: any domestic abuse victim, stalking victim, sexual assault victim, observation without consent victim, or unlawful photography victim who has been subjected to, threatened with, or placed in fear of domestic abuse, stalking, sexual exploitation of a minor, sexual assault, human trafficking offense, observation without consent, or unlawful photography, may seek relief under this part by filing a sworn petition alleging domestic abuse, stalking, sexual exploitation of a minor, sexual assault, a human trafficking offense, observation without consent, or unlawful photography by the respondent. In this case, the petition that was filed by Ms. Ratliff alleged that she has been subjected to stalking. And as a result of that, the proof in this case is overwhelming that Ms. Ratliff has been subjected to and has been the victim of stalking. Therefore, I find that she has substantiated the need for an order of protection. I understand Mr. Hodges' objection to his loss of firearm privileges. That is a provision of the law that anyone who is under an order of protection is subjected to, and for this court's consideration, the evidence would be sufficient, in my opinion, that justifies the loss of the right to have a firearm in your possession. After reviewing all of this information, clearly, Mr. Hodges, that while you may seem today to be very rational and calm, the repeated and persistent efforts that were made to contact her against her wishes do arise to the law of stalking, and therefore I'm of the opinion that the order of protection should be issued and extended for 1 year. I will issue that document in just a few moments, and you can both have a copy of it. Ms. Ratliff, if you would like to wait in the courtroom while I fill out the paperwork, then you may do so, and I will have the deputy serve Mr. Hodge out in the lobby. So that is the ruling of the court.
This courtroom case took a wild turn. The ex-boyfriend admitted he kept contacting her after the breakup, but claimed it was never meant to threaten her. He blamed guilt and regret, said the flowers, messages, and nonstop calls were just attempts to talk. But the judge wasn't buying it. After hearing about fake numbers, repeated contact, social media posts, and surprise visits, the court ruled it was stalking. Then came the bombshell. The judge ordered the protection order extended for a full year and stripped his firearm rights. The judge said the evidence was overwhelming. What do you think? Heartbreak gone too far or clear stalking? Like, comment, and subscribe for more courtroom drama.